and welcome to today's segment of The Power of Money. I'm your host, Michelle Graves, affectionately known nationally and internationally for the last 38 years as the Money Lady. And as always, I remain committed to bringing you financial issues, items, people, experts, and authorities so that you and your family can be empowered to make good, sound financial decisions. Because, like it or not, money runs America. And if you're at the bottom of the heap and you don't understand how this works, well, you're just going to stay at the bottom of the heap. And that's just not really where my heart is. Today, I have another amazing guest who I have known for so long that if I told you, you'd probably start trying to figure out my age. But he's attorney at law, Edward Garrett, and he has been involved in the field of banking and finance for several decades, 3 decades at least, and specializes in credit, bankruptcy, foreclosure challenges, and I've got him on for the next hour. And you do need to sit down and you need to call your friends so that they can hear what this man has to say. I have referred many people to him for all kinds of things because he is a specialist and knows his trade. So I'm not going to continue to talk about him. I'm going to let you meet and hear from the man himself, Edward J. Garrett, Jr., attorney at law. And good to see you
Hello,
again.
Michelle. Thank you very much for that nice introduction.
It's the truth. It's the truth. How long have you been out here?
You know, I've been involved in financial matters since 1977. So as you mentioned, it's probably a few more years than I would like to admit. But over that period of time, and particularly with regard to legal representation, I've been able to work from both sides of the banking relationship. For much of my career until 1993, I was counsel for financial institutions.
Well, I remember you were chief counsel with the largest S&L in this area, Gateway.
That's correct. That's
and
correct.
That's where I knew you from. You were the hammer at Gateway, which handled all kinds of mortgage loans.
Sure.
You knew the business.
Sure.
You were highly respected.
Yeah, I appreciate that. And as the banking industry progressed, which is a perfect example of what occurred to Gateway, is that a larger financial institution acquired them in 1993.
I remember.
And that process has even become more aggravated in the last 10 years or so, where basically financial institutions now are mega large corporations.
They are.
There are very few of them, and they carry a lot of weight, and they scare consumers and exert a lot of control over their financial well-being. Well, with my departure from Gateway in 1993, I had the opportunity to enter into private practice. I opened a credit services organization out of Cincinnati, where nationally we deal with credit report issues. But in addition, I've developed a law practice wherein I am representing consumers instead of representing financial institutions.
That's an interesting twist.
It is an interesting twist. And between the two, I'd rather be on the consumer side.
I believe that. I absolutely believe that. Consumers have so much that happens to them in the course of a day around money.
That's true. And you know, so many times when a consumer has a financial problem, they either ignore it or they frustrate it in one way or another until eventually it just compounds itself and becomes a much larger problem than it might have originally been. So one of the things that I really have been working with most recently is dealing with consumers before their situation becomes helpless, and advising them in some ways that what they perceive as very serious financial issues are probably not quite as serious as they are considering them to be.
Well, you can understand why, though, because banks are just, they're huge.
Yes, they are.
And you look like a little chicken, and that's a big fat buzzard, and you're getting ready to get on their platter. People are scared and they're uncomfortable, and let's be honest, attorneys can be intimidating too.
Yes.
You know, which is, oh my God, he's going to think I'm really dumb. And the answer is, well, you know, he may or may not, but he's there to represent your best interests.
Sure, sure. And I think what people need to realize is that despite the fact that a financial institution is so large and so scary from their point of view, the elements of law still apply. I mean, you are entitled to due process. You are entitled to force the bank to prove whatever claim it is they're presenting against you, and you are entitled to a free and impartial hearing if you and the bank can't come to terms. So very early on, I think consumers need to recognize that, you know, this bag full of rights that they have constitutionally and procedurally in our courts, particularly in Ohio, they should be well aware that that has some serious leverage. And leverage enables them to negotiate with the financial institutions to a much greater degree than they might have ever imagined. They're never going to be made aware of their weight and ability to negotiate by the financial institutions.
No. Why would they?
Correct.
I
so
mean, they're
it
not in the
behooves.
business of educating you about your rights.
Yes, and
trying to
the
collect.
contact that a consumer receives from a financial institution is always a collector. You know, it's someone that sits on a headset all day long. They may be in the Philippines, making continuous telephone calls, threatening, trying any method they can just to get a few dollars from the consumer out of fear, without respect to what limitations of collection there might be.
Can I ask a question as it relates to that? If a bank, well, we know under bank rules that the bank is only going to carry a bad debt for so long, and then they're going to dump it. So these collection agencies are basically independent companies that may have bought that bad debt, yes or no?
Well, you'll see a variety.
Okay.
First of all, there are current items and scheduled items on a bank balance sheet. So, for example, if you pick a major bank and let's say there is a revolving charge credit account.
Okay.
The bank will carry that, and either that financial institution, that bank, or some other financial institution will handle what's called the servicing on that particular account. So while it is current, someone collects the payments, reports back to the bank carries it on their balance sheet as an earning asset. Now, if the payments are not made and the loan falls into default, then the bank must remove that from its active assets and put it in another category of problem assets. That's typically what's called charging off.
Right.
Now, once the item is charged off, most major financial institutions have their own departments, collection departments, wherein they will make the first efforts to try to collect.
Okay.
And, you know, these will be the ever-increasing threatening phone calls, the all-out efforts to just get a few dollars. And,
something.
yeah, and at the same time, there's this tremendous snowballing effect of delinquent interest, late charges, penalties, and things, which can take a very small principal obligation and turn it into what the bank would call a major collection. I mean, sometimes 3, 4, 5 times the amount being borrowed. And the whole while, these, in my opinion, usurious interest rates of 30% or so
I think that's
continue to
usurious.
accumulate. Now, once the bank fails to succeed in that collection effort, many times they will either assign or sell the collectible account to a third-party credit agency, collection agency. And they sometimes do this for pennies on the dollar. Sometimes they'll do it on a commission basis where they share in the proceeds. But the process is still the same.
Right.
You know, it's going to be an increasing barrage of collection efforts,
And
just in the hope that
balance gets bigger and bigger and bigger.
Yes, yes.
So what could start off as a $500 bad debt, by the time you add on penalties and interest and fees, and then if it's sold to a third party, and then they have their add-ons, that can easily go $3,000, $4,000. Is that not correct?
Oh, if not more.
If not more.
Yes.
So the person at that time is really, really intimidated and scared, because what started off as a small debt that wasn't paid is now a huge debt.
That's correct.
And is collectible for how long?
Well, it's collectible for as long as the statute of limitations still permits the creditor. And this all tolls from dates of activity. So you're going to be dealing with it for a while. But one of the things that the financial institution or the collection agency does not make the consumer aware of is as you progress through this process, the longer the period of time from the last payment made on the account, the greater the bargaining and negotiating ability of the consumer to settle for something other than that being demanded. Now, consumers by and large make very poor negotiators. I
would definitely not negotiate with a bank.
That's correct. In fact,
and I do, and I'm a banker. I would not negotiate with a bank.
Right.
Okay.
Right. In
No,
fact,
no,
my advice is for the consumer to communicate nothing to the
Period.
bank if they don't have the ability to pay the debt. Instead, contact someone on your behalf, an attorney such as myself.
Yeah, right.
Just the introduction of an attorney into the process assures that the number is going to be dramatically reduced. The collection agencies recognize this. The collection departments within the financial institutions similarly recognize this, and the price of poker goes down
That's so
the day that
amazing.
an attorney steps
Yeah.
into it. Now, one of the things that consumers tend to do, which is a very serious mistake, is they accept as valid the claim being made by the bank. And it's a difficult position for a consumer to understand, but the best place for that collection demand to wind up, from my point of view as an attorney, is in court. This process of demanding collection through the collection phase really is not as productive as what your negotiating or settlement ability will be once the clock starts ticking after the financial institution actually files a lawsuit against you.
Wow.
Yes, and you know, it's a scary
Oh
thing
my God.
for consumers
You want them to go to trial.
Yes, yes. I want to be in court.
Okay.
And
before a jury of your peers.
Well,
does
typically
it
if
have
you're
to-
most of these cases aren't going to be before a jury.
Okay.
And the cost of that is prohibitive.
Okay.
But in front of a judge, a trier of fact,
Uh-huh.
and more importantly, in the process, which assures the consumer their constitutional due process.
Okay.
And the principles of jurisprudence. In essence, what that will dictate is that the claim against you must be proven to be valid. And the pursuing party, that is the plaintiff bank,
Right.
must prove by a preponderance of evidence the elements of whatever it is they claim, which in essence is going to be a contract or the existence of an account.
Signature, etc.
Yes, yes. And I don't know with certainty, but it is my suspicion that particularly with regard to credit card accounts, financial institutions have long since made a cost-benefit decision that it is less expensive for them to risk going to trial than it is for them to keep the expense of proper record keeping.
So they don't have documentation.
They can't prove their case in
Right.
many,
And
many
millions
cases.
of people have credit. I mean, unless they have computerized all of that, but I suspect they haven't.
They have not.
And therefore, their claim is not valid.
Right. There's something in the law that's called burden of proof.
Okay.
And that is that the party proceeding must present evidence sufficient to prove their claim.
Okay.
And that's the bank's obligation
Yeah.
in the scenario that I've just described. So at a minimum, bank needs to present an agreement that shows the relationship between the parties, binds each of the parties, describes in detail all of the rules of the obligation, and operates contemporaneously with the dates that are involved. Secondly, the transaction history needs to be proven that during the existence of this account that the bank can show the proceeds being borrowed and the proceeds being paid and provide an account that goes from zero to whatever number is being
Right.
proven. I have handled maybe 25 of these cases in the last couple of years, and I've yet to see that be done.
My word. So what happens, may I just fast forward this, Attorney Garrett, what happens when you go to court, they're not able to prove their allegations and document the demands? What happens before a judge?
Well, and in that instance, judgment in favor of defendant consumer. Now, what will happen many
Wow.
times is that the financial institution will withdraw their complaint. They'll dismiss the case.
Right, which is we're not even going to do this.
Right, and then maybe raise it at a later date, although that is the exception. But you were saying winding your case into court. I think that's an important thing that consumers need to key in on. Service of process is a term of art under Ohio law and the rules of civil procedure. That is the formal way by which you receive notice that you've been sued, calling you into the court to present whatever defense you have. Now, under the Ohio civil rules, there's kind of a quirky little way to obtain service of process.
Tell me this, because
okay.
this is so bizarre.
Yes, this is.
Is this the case in Kentucky or Indiana? Do you know?
No. In fact,
okay.
Ohio is somewhat unique. It's
Okay.
one of the easier states in the United States by which to assure service of process.
Okay.
So the process is this. Bank's attorney files what's called a complaint.
Okay.
And just basically that's an outline of the allegation that there is an account, it's not been paid, dear court, please award us X number of dollars in judgment. Now, under the rules, that complaint is sent out by the clerk of courts, which triggers a 28-day period of time for consumer to answer and defend themselves. Now, the means by which that is served under the Ohio rules is that the clerk of courts will send a certified mailing to the address that is provided by the plaintiff's attorney.
Okay.
Now, should that item go unclaimed or be returned without signature, then the second step is for the clerk to send by ordinary mail, in essence, to the same address.
Okay.
So a lot of people, that, particularly that are having financial problems, will see a certified mailing
And they
receipt on
won't
their
sign.
door,
Yeah, they're
and
not
they
gonna-
run away.
Right.
Well, when you run away and you ignore that, you assure that the bank then gets to go into court when you do not answer in that 28-day period and allege all of the facts as presented to be true, obtain the judge's approval on that, and they win by what's called a default judgment.
Right.
So then they could proceed directly into garnishing wages, garnishing bank accounts, attaching assets, whatever, to try to get at your proceeds. Now, when you allow that to happen, and I can't say it more vehemently, whatever consumer is receiving notice of a lawsuit needs
Respond.
absolutely respond, because here's the opposing procedure that
Okay.
would happen. Go claim your complaint,
Okay.
and then take the complaint to an attorney,
Right.
such as myself, and here's what I will do with that. First of all, I'll answer the complaint, and in essence, we will deny the allegations as they're set forth. We will assert what are called some affirmative defenses, but you then get into the framework of forcing the plaintiff's lawyer to sue to prove their case, and that is easier said than done. Because of the ease by which a default judgment is obtained, and we've done some research in my office about this, upwards of 95% of these cases that are filed, nobody ever answers. So that means that collection attorney on
That's
behalf
easy.
of bank
That's
is
easy.
winning all these cases.
They're winning all these cases under default.
Right. But on the converse, what that means is if you're one of the smart people that are actually responding to this, then you're going to force that attorney to do something he's not comfortable doing, which is proving his
Prove
case.
your case.
And one of the reasons that the collection attorney for the bank is not comfortable in doing that is because the bank usually will not have enough records. So again, in that example where someone comes in my office with this, we file the answer, set up the affirmative defenses, but I immediately send out discovery requests, which is another privilege.
Give us stuff. Okay.
Show me what you have.
Right.
And invariably, they kick around for 30, 60, 90 days. Nobody at the bank knows how to answer them. They don't have enough records. And whatever they do have eventually shows up in my office. Well, I'll see, for example, an account. Let's say it's a 15-year-old account.
Okay.
So we go all the way back to year 2000.
My God.
They present a document to me that they claim to be
The original
agreement.
Okay, the agreement.
Okay, well, this agreement is a little flyer that folds out to about 21 pages and talks about everything in the world, but it doesn't show my client's name.
Right.
Doesn't show the account number.
Right.
Doesn't show my client's signature. And down in the corner of the last page, there will be a little copyright that says 2011. So the obvious question is, if you claim there's an account from 2000 and you're showing me a document that postdates it by 11 years, this surely can't be the agreement.
Right.
So where is the agreement?
Right.
Tough position for them to be in. Similarly, when they hand the account statements, and by the way, I ask for a history, not account statements, because those are self-serving and they have their own evidentiary problems. But invariably, they'll send me 18 months worth, probably somewhat recent, but never do they produce anything that goes back to the year 2000. Well, when they give me that little snapshot in the later series of that particular account activity, then there will be a previous balance that's indicated, which is going to be very high. So that raises the question of fact, well, if you're demanding $20,000 today and you can only present me account statements, one of which has previous balance of $15,000, where's all that information? So again, it's a matter of proof, and because it's an ongoing account, all of that becomes very important. And the judge sits in ruling of these types of things. And I think the judges are somewhat sensitive to the fact that the bank is really trying to steamroll the client, and that the bank has not met the burden of proof that is required them under the law. So it is not at all unusual for us to obtain judgment in favor of the defendant consumer in these cases.
So what happens? How does this play out? Because I've got a lot of thoughts that pop in my head fairly quickly, one of them of which most people in Ohio are not aware that you can wind up losing everything to this dumb stuff. It is very serious. And the statute of limitations in Ohio, is it not true that can be extended again? I mean, if you haven't enforced, it can go back.
It's basically a breach of contract statute of limitations, but it tolls from activity dates. So they'll play that. But when I mentioned earlier, affirmative defenses, the statute of limitations is one such affirmative defense. So when we file our answer and submit our affirmative defenses, that's always one of them.
Okay.
Yes.
Because that's pretty important. I don't think people are aware that even if they send it to an invalid address, they can still get a
That's right. That's right.
You. I mean, that's horrible.
Well, and there's basically two popular ways to collect on a judgment.
Okay.
See, once the judgment is obtained, they can garnishee, which is basically
take your wages. Yeah.
Right. They can take your wages, and that's somewhat watered down. I mean, there's depending on the amount of your income and the number of dependents that you have, they might not be able to get two wages on a low earning arrangement. But they can, if they know what financial institution you have deposits, they can go in and take to the amount of their judgment against deposits that you might have.
That is absolutely
right. So another thing that I always counsel people that are having these problems is the bank does know what bank you've been using, either from the application or from the checks that you sent when you were paying for the account. So at an absolute minimum, to assist you against a judgment attachment, go put your deposit somewhere else.
Right.
They have to file a processing fee with each of these garnishments that they serve, and it can get expensive. I mean, there are still a lot of small community banks, and they're not going to front that money. So, if you're at Bank ABC,
big bank ABC,
and they know you're there, get to Bank XYZ,
your credit union or something,
and have your deposit
right,
account, so they're not looking for that.
Just as a bare minimum.
Yes.
Which I have counseled people, which is, do not put yourself in harm's way, because these are banks, and you may not like it, but this is not a loving, friendly relationship. It is business, and they will do what is necessary
Yes, they will.
to enforce that agreement. And they don't care if you can't pay your bills or feed your kids. It's a contract, and they want their money. I just counsel people simply, and you know this, Ed, over the years, you need to call Ed. You know, you do. This is what he does. You need a fighter. You need somebody. Now, one of the concerns that's been expressed to me, and I have to be open with you, we're open friends, is people are always nervous about fees, which is, well, I owe these people $10,000, but I can't afford. If I can't pay them, how can I pay him? How does that play out?
Well, first of all, you can completely dispose of the amount being demanded by the bank.
Mm-hmm.
Banks are in the business of lending money.
Period.
In a credit card scenario, the last thing they ever want is their principal. And the reason for that is because they earn interest at such a tremendous rate.
Can you
so,
not?
You know, it's not unusual to see a $3,000 principal obligation become $15,000
Yes.
in demand.
Yes.
Well, I won't even open discussions with a bank at $15,000 if this shows up in my office. You know, let's work back here on the $3,000.
Okay.
You know, I take these cases on an hourly basis. I mean, I've yet to hear a client complain about that.
I'm
in fact,
sure.
it's kind of fun when we tie up the bank.
Uh-huh.
I think it is also important to understand that if we do get to trial on one of these cases, which is not always the case, I mean, many times they'll dismiss the case, but if we do get to trial, the bank is kind of in an embarrassing position. They will fly someone in from who knows where,
Yeah.
South Dakota or New York
Okay,
City or somewhere, to our little local court, and he'll take the stand, and I get an opportunity after they try to present these haphazard and incomplete records to pick them apart a little bit. And one of my favorite things to do is to attack that interest rate. Now, ignoring for the fact penalties and late charges and things of that nature, but just dealing with the raw rate of interest. I always make it a point when I have an opportunity to cross-examine one of these bank representatives is to do a little background search with regard to their cost of money versus what they're charging you in interest, so that the judge can understand what is fair and what is not
Right.
fair. So in particular, I had one case, and you need to understand that banks borrow the money they lend.
Right.
And it's called the federal discount window.
Right.
And
0.05.
right, it's 0.05. It's 0.5% is what it costs a bank to borrow money. But they'll put it out, and again, ignoring late charges and penalties, they'll put it out at 30%. And they put it out in North Dakota because that happens to have a higher usury rate than what Ohio would permit. So their interest rolls along at that. Now, there's an old financial rule, which is called the Rule of 78. And basically what you do is that you divide your interest rate into 78, and it will tell you what period of time is necessary to double the amount of principal. And using 30% to 78, it's probably 2 years and 4 months. Your $1,000 debt becomes a $2,000 debt. So I point that out and I walk them through that process. I'll also do an analysis of just what the interest rate represents. So at 0.5% against 30%, that's let's say a 3,000% markup.
Yeah.
And
you're making more money than the mafia.
right. And I've actually had cross-examinations in a courtroom where I asked the question of reasonableness of the bank representative, and I said, there's a coffee shop downstairs, they sell coffee for $1 a cup.
Okay.
And let's suppose you were coming through this morning and you bought a cup and you walked up to the counter and they said that'll be $60. And would you consider that fair? And God is my witness, I had a bank representative say, yes, that would be fair. And the judge rolled his head. So, you know, the experience, yes, you have to pay me to be in court, but it could be a very rewarding experience.
Yeah.
In that particular case, I think, was somewhere around $35,000, and my client walked with no obligation whatsoever.
See, and wrote you a check.
Yes.
and said, have a nice
And
day.
I think the cost of my defense were maybe $2,000.
Right. That to me, if you find yourself in a ditch, that's the only way to get out of it.
Yes.
It seems to me. Because alternatively, not only do they mess you up financially, but they ruin your credit.
Yes.
And that sits on your credit report for how many years?
A trade item can continue to be reported for 7 years.
That's a long time.
Yes,
It'll
it is.
ruin your scores.
Yes, it is.
I mean, really.
But I'm happy to say, because
Okay.
we work with credit reports as well through my company, Credit Improvers Incorporated, on a national basis. And in essence, the record keeping that the financial institution has with regard to their credit reporting is almost as weak as what they have with regard to collection of the debt. So
Okay.
we actually have a guaranteed program, 100% money back guarantee, that will go into the credit reports, challenge these items under the Fair Credit Reporting Act, and in essence have a large number of these removed and boost those credit scores. So I would never, in counseling a client, yes, you're not paying and something's going on in your credit history that is derogatory, but don't let that control your decisions.
Okay.
That's something that can be addressed at a later date.
Okay.
And very effectively addressed.
Okay. Because one of the questions that I have to ask, and I'm asked a lot, is there such thing as legitimate credit repair? What works and what doesn't? And how do I know who I'm getting involved with?
Well, see, I actually find, and I've owned Credit Improvers, which is one of just a couple of properly licensed and bonded companies in the state of Ohio. That term, credit repair, is offensive. I mean, it flies in the face of what the company actually is. They're called credit service organizations, and they operate under a very specific statute. And no private corporation can, quote, repair your credit.
Okay.
Instead, what they can do is lead you, a properly licensed and bonded company, and you can find this out through the Department of Commerce, who is and who isn't. They can assist you in the process of using a very strong and useful federal statute called the Fair Credit Reporting Act to challenge the information being reported.
Okay.
And the dirty little secret in the credit reporting business is that the bulk of what's being reported cannot be validated as required under that statute. So what we've done at Credit Improvers is we've coupled my legal representation with the services of my credit service organization to the extent that we very forcefully present these challenges, and when they cannot meet the criteria required under that federal law, the law requires that those items be permanently deleted.
So they cannot recur.
That's right. So the question is, can you improve upon your credit reporting? Yes, absolutely you can. And if you use a program such as mine, you can do it very effectively and very successfully. But in terms of credit repair, my company can't go in and do anything to change the reporting. We're not in that equation. That's financial institutions reporting to credit bureaus. And when that term credit repair gets out there, people misconstrue that thinking there's some influence. There isn't. It's very similar to what I've described earlier on the collection case. Make them prove their case and show that the emperor has no clothes, which is the nature of the banking industry at this point. It's fast, it's loose, it's big numbers, and nobody's doing the detail work. But that detail work is how you save yourself.
Well, let me ask you, if you could, and I don't know how to put this, but let me just put it straight. Have you gotten involved with any of the payday loan situations where people are sinking, having gotten tied into that industry?
I'm not, and I'm glad you raised that, because there's something that happened here in Ohio recently. There was a payday loans, if not used properly, are a device by which someone can throw an anchor off a boat, hang on tight enough to drown themselves. And what happens is there's no real credit underwriting. There's no analysis of whether or not you could pay.
They don't care.
So instead of a one-time deficit financing plan, instead it's someone trying week after week after week to just meet what are their ordinary expenses. And every time they do that, there are extraordinary fees that come into play.
I just can't believe the fees.
So that was a very sensitive issue when presented in a sympathetic way. And couple that with the fact that the banks don't like that happening because they already have credit card accounts that will sink these people into debt just quickly enough and obtain income for the banks as compared to payday loan companies. So payday loan companies were done away with in Ohio recently. And they were
in exchange for title.
Yeah, title loans, where if you have a car or something, they'll take that. But another interesting little wrinkle, when they changed that law abrogating the payday loan companies, they allowed a privilege for consumer, for credit service companies such as credit improvers to make payday loans. So now the old payday loan companies are buddying up with credit service organizations in an effort to solicit these same type of loans. Now, I've been asked by a number of these to join in that process, and I refuse to do it.
I mean, that's
just
totally ethically. I
don't
how
want to
the
make my
heck
money on the
can
shoulders
you,
of someone like that.
Yes. So how does a person, I had a young lady call me, and not as a client, but just, she said, I can't get my life together because all my checks are, I'm going from pillar to post paying these people. And I said to her, well, I referred her to you, but I also said to her, are you prepared to tell them you're not going to pay anymore? Just tell them, work out an amortization plan and don't pay them anymore.
Or don't do it yourself.
Yeah.
There's another unique privilege in Ohio, which is consumer credit counseling.
Right, which
So-
she said she had gone to, but it was, they recommended bankruptcy.
Well, that's
And
probably
I
a
said,
mistake.
no,
It doesn't
no,
usually fit.
no. I said, I don't, not for this little bit of debt.
No, and the consumer credit counseling company has the ability to stall the collection process.
Okay,
Force an agreement.
but how do you find a good one? Because there are quite a few out here, Ed.
Better Business Bureau.
Okay,
That'd be my recommendation.
go back through the Better Business Bureau and see what the ratings are.
That's correct.
For these people. I was just concerned because I told her, I said, you don't file bankruptcy over $1,000.
No.
I said, the attorney fees are going to be that.
And bankruptcy changed in the mid-2000s, wherein previously you could discharge your debt. You could file a Chapter 7, walk away. If you have even minimal income now, you're not able to do that.
Oh, my
Instead,
goodness.
it's more like a 13
Yes,
wage earner plan,
yeah, okay.
where you have to set up a repayment plan. So
Okay.
that's why I tell people, use some of these defenses that we have and negotiate your debt as compared to filing the bankruptcy.
Yeah, okay. What about foreclosures? What happens there? Do they stay on credit report for how long?
Again, 7 years, but the public record item can continue.
My goodness gracious. So they've got that black mark on that
That's
as
correct.
well. Are you able to help people with that?
Yes, very much so. Could I have a glass of water, please?
Hold on, I'm going to give you actually a glass of water if you don't mind. Hold
Sorry
on.
to interrupt you,
No,
but
no,
I've
no,
been
please.
talking over a dry throat.
No. Here, let's try this. Here, there we go.
Thank
Try
you.
that. Okay. Okay, just keep that right there and,
That's much better.
okay, perk up. Here we go.
Okay.
Okay.
Yes, foreclosures give you a tremendous opportunity to negotiate.
Okay.
The things that a consumer is concerned about with their foreclosure is this tremendous number that's coming at them,
Yeah.
probably as a deficit judgment. And the bank is interested in acquiring title to the property very quickly. So again, one of the things that consumer needs to do is to contact counsel as quickly as they can, because in exchange for agreeing to a title transfer on the property, the bank will be more than anxious to negotiate the numbers. And the sooner you get involved in that process, particularly where you set up your defenses and make it appear difficult to proceed, the greater the likelihood you're going to walk away at a real savings.
So is it possible to do a deed conveyance?
Yes. Or an agreed entry.
An agreed
in the
entry or
judgment.
something like that?
Correct.
Now, let me ask you, if in fact you do that and there is and the bank agrees to settle for a lower amount, is there a tax liability?
Yes, there is.
See, here we go again, Ed. I mean, my God. So you got a $200,000 house. The bank agrees to, your balance is 100. They agree to a walk away, and the difference is taxable.
Yes.
And so here comes the IRS.
It's imputed income.
Imputed income, unless you, as the attorney, negotiate for the bank to forgive it. Can the bank forgive it?
Oh, yes, the bank can forgive any debt owed them.
Okay,
but they can't change the tax consequence.
They can't change the tax
Correct.
consequence. Do you realize how many people are out here who are basically going to be thrown under the bus with that law?
Oh, without question.
I mean, that's significant.
Right, and the rules interpreting that income have changed, excuse me,
Yeah.
in and out with regard to the HARP and the 2008 experience.
Right.
So, but at present, it is a taxable consequence.
So a person who's trying to do the right thing is still going to get stuck. And I must be honest with you, the IRS is a lot scarier than the bank because they do have criminal.
Absolutely.
You can go to the prison.
Absolutely.
You can go to jail.
Right.
I mean, they can't kill you, but you can't go to jail.
That's correct.
So here we are again.
Yes. I didn't say everything was easy.
I never said it was easy either. I've been out here for a long time. I've seen a lot. And it just seems to me that, come on, banks are making billions of dollars. Billions. And most of it is fee income, spread between interest at a 0.5 point and 30%. I mean, that is legal. And the poor consumer doesn't have a clue.
No.
They just don't have a clue, period.
And they're intimidated.
And
they have no idea what their rights and their powers are.
Right, exactly. So just from where I'm sitting, if a person is having challenges meeting debt obligations, credit card, etc., before they find themselves in a hole, should they call you?
Absolutely. Sooner the better.
Just so that you can intervene?
Yes. And again, the perspective from the bank changes when you have counsel.
Okay. And let me, if you turn this to me, please. Thank you, Ben. Let me share something with all of you viewers. And I've said this over the years, and I'll continue to say it. Please don't try to swim with sharks, and you're a guppy. I love guppies. I love tropical fish. But don't do it. There are people that are basically, in the old cowboy terms, hired hands, hired guns. It's their job to get it fixed. It's not your job to try to fight a shark. You don't have the teeth, you're too little, and yeah, you're going to have to pay because it's business. But if you're having problems, and I'm telling you, 38 years of doing this stuff, and I've seen more sorrowful stories than I can ever talk about, when I'm just falling out and crying. Get legal counsel who knows what they're doing to work on your behalf so that you can get out of this hole. Nothing is worse than a shark deciding that you'd look great on the dinner plate. Okay? So those are my thoughts. We're going to go back to Ed. And?
I can agree with that. Absolutely.
Is it personal or it's just business?
Well, that's it. And you know, the consumer, it's everything to them. I mean, you know, they receive a telephone call.
Oh, yeah.
You know, the kid needed braces or the car broke down. And all of a sudden, the entire collection process of that bank is turned against that consumer. And they have no recognition other than what's being demanded of them of exactly what their rights are or how little the bank might take. So, you know, again, the sooner you have representation, the better it's going to work out for you.
So optimally, for in today's market, because so much is automated underwriting, meaning they just look at credit scores. They don't even look at what you're doing. They just look at your credit scores. And depending upon your scoring, you'll get one rate of interest or another. I mean, a huge company, Capital One, is now pushing on Facebook, etc., where based on your credit score, they can tell you what credit card they can offer you.
Right.
And I'm like, okay, truck over your head. But this is where the industry is,
Sadly.
sadly. So what can a person do right now to improve their score?
Well, the first thing they should do is get their credit report. Take
Okay.
a close look at it, see what's on there.
That's annualcreditreport.com.
Exactly right. Do
The
that
only
once
one.
a year.
Okay.
And then, if you see items that aren't yours, you can challenge, or better yet, give me a call.
Okay.
Let me take a look at it. I'll review that at no cost and let
Okay.
you know what it means and what can be done about it.
Okay. So that's the first step, is to get their credit report and to make sure that there are no inaccuracies or bad reporting, etc. If they do have errors, then they can try to do it themselves, but I wouldn't know what to tell them to do. I have no idea how you go into the market and try to get stuff off.
Well, and usually they do it the wrong way. And again, it's a burden of proof issue.
Right,
You know,
exactly.
many consumers challenge trying to prove something when in fact it's the creditor required to prove. Excuse me.
That's okay. That's all right. I hope this water is helping you. So they can come to you at no charge for that review.
That's correct.
And if it's pretty significant, then they probably would want to retain you. What is the typical cost for your company?
$399.
That's it?
That's it.
Are you serious?
Dead serious.
$399.
Start to finish. We
Start
guarantee to
to
improve your credit reporting.
Finish.
Now, on the legal representation on these other cases,
Oh, that's different. Yeah.
yes, that's an hourly basis.
Right, because you're an attorney. You
That's
know,
correct.
Right, okay.
But realistically, a case, I'm sorry,
I know, that's okay.
I'm joking to death here.
Well, I don't want you to be dying in here, not on my watch. I haven't seen you in a little bit, and I certainly don't want you filtering over. I really don't.
But at any rate, I usually set up retainers somewhere in the $1,500 range
Okay.
to
Well,
defend
then-
one of those cases. And
Okay.
in most instances, that'll get us to where we need to be.
Okay. Now, let me ask you this question, because you talked about bankruptcy, talked about it's bankruptcy, you say, is really not as legitimate. I shouldn't say legitimate. That is an improper term. But it's not as useful as
Should be your last resort.
last resort.
Absolutely.
Okay. Just because it does not offer the outcome that you might expect?
It's going to carry a long-term consequence.
I know it
And
is.
it also negates the ability to pick away at the balances. You know, again,
Real,
using those
okay.
early examples, if the bank is demanding
Right.
$30,000 from you, well, that might only be a $5,000 debt.
Got it. And you can probably work that. Is it possible to negotiate that down and to put it under a 13? Just
Yeah, but you don't need the 13 if we can do it outside
Okay.
of filing the bankruptcy.
okay, I got it. So that is, you can negotiate to settle. The other thing would be with your foreclosures, you can negotiate to settle.
Yes.
The consumer can't, but it's legal.
counsel.
Through counsel.
Right.
Can negotiate to settle with the bank's legal department.
Or alternatively, if in a foreclosure, the wish of the consumer over negotiating debt or release of debt is to stay in the property as long as possible. You know, these things can be dragged out quite a long time.
And bank their money.
Absolutely. I mean,
Oh,
while you're
brilliant.
not making payments, you're staying
Brilliant.
rent-free.
Right. You're staying rent-free.
Right. And then if you have one of these entirely hopeless situations where ultimately you're going to file bankruptcy, when you file the bankruptcy, it's called a stay, but you stall the foreclosure action and the whole thing starts on another timetable. So it's not unusual for, you know, just through the tactics of the legal process and the procedural aspects of that and motion filings and so forth that you can get 2.5 years
Oh my
of a
God.
free occupancy, and then you file bankruptcy the day of the sheriff's auction, you might get another 18 months.
For the court to be gracious to you to try to.
Absolutely. So, a rent-free occupancy, for 3 or 4 years might be what that particular consumer wants. And,
Right.
there's a
And
process
they can
to
accumulate some
accomplish that.
funds and move on when they have to.
Sure.
That's
now,
amazing.
right, but again, now remember, that's probably building a deficiency judgment.
It surely is.
Yes.
It surely is. If you're looking at accrual of the interest
Right.
and your penalties, you're going to have a challenge.
But there are also people that are, quote, judgment proof. So, for example, if,
Okay.
public benefits are not attachable. So if someone's on Social Security or long-term disability, and they really have no savings to speak of,
Right.
who cares how big that judgment gets, because there's
It's
no
not
way,
enforceable.
right? They can't. The judgment holder can never get any money from you. So in that instance, certainly, if you can
Yeah.
get me 4 more years in my house, Mr. Garrett, please do so.
Right. I'll be
Right.
happy to pay you. You know what? In the remaining time, because time has wrapped up, if you can believe that, we have not covered some other areas I wanted to talk about. But one of the things about America is that, like it or not, all of us are going to ultimately have to deal with attorneys. Is that not a fair statement?
Why do you think I spent all those years in law school?
And my question is, and it's a germane question, is how this entire system is geared from politicians on, who are attorneys. The laws that are in process, everything is written by attorneys, interpreted by attorneys, and ultimately adjudicated by attorneys. So the consumer is kind of out here. So how do you pick a good attorney, and then give me a phone number, and then we're done?
Well, I think the first thing you need to do in selecting an attorney is have a recommendation from someone
Okay.
that you trust. Every year, thousands of attorneys graduate.
I know, it's
they
a sad
have
story.
exactly the same license as I have
Yeah.
after practicing since 1983. But not all attorneys are equal. When
Okay.
you come out of law school, you don't know where to find the courthouse, much
Yeah,
less help your client.
uh-huh.
So keep your ear close to the ground, listen to people that know what they're talking about, and if they give you a recommendation on an attorney, follow through with that, and get your own comfort feel for them. You'll know within the first 5 minutes whether or not the attorney knows what he's speaking of.
Okay.
And that's important. Anyone that would like that 5 minutes to find out if I know what I'm speaking about, I'd encourage them to call me at my office, which is 513-421-8888.
Say it again for our seniors.
513
Okay.
421
Okay.
8888.
Okay.
And I'll be happy. I've never not answered a telephone call. And,
This is true.
if nothing else, we're going to have an interesting conversation.
Yes.
And I certainly, it's somewhat rewarding to me when I'm able to intercede and help someone, because just far too many times good people wind up with real problems. And I have a personal animosity with these giant banks scaring people, trying to obtain from them usurious proceeds. And if I can intercede in that regard and help a family or help a solid individual, I'm happy to do so.
Well, folks, can I have the camera? You heard it. And he's my personal recommendation for this specific practice of law. Okay? Michelle Graves. Been referring people to him forever. And frankly, I use him. Why? Because he's good. It's simple. And I would encourage you, if you're running into challenges due to hardship or circumstances, etc., do your own homework. But just remember that I referred you to Attorney Ed Garrett, or I should say Edward J. Garrett, Jr., attorney at law with offices in Cincinnati, Ohio. But I believe he's licensed in Kentucky. Am I right?
That's correct.
Kentucky and Ohio. I don't know about Indiana. I don't know.
No, I don't
not
practice in
Indiana.
Indiana.
Okay, you don't practice in Indiana. So my people that watch in Indiana, I can't help you. But I can hopefully you've learned some things. I hope it wasn't too difficult. But the bottom line is that you always are going to need somebody to deal with you when tough things happen financially. And he is your go-to attorney. I'm Michelle Graves. It's been a delight and a joy, as always, to have you to be a part of my world. And today it was about Edward J. Garrett, Jr., attorney at law who specializes in credit, bankruptcy, foreclosures, and has been in the practice of law since 1983. So thank you for being a part of my world. I appreciate you listening in, and as always, have a great day, and God bless you. Take care.